I'm talking about serving the documents specifically. And in particular, those of you who deal with cases involving Section 21 notice will know that a regular argument that occurs is tenants saying, I never received the documents. So I didn't get my gas safety certificate, I didn't get my EPC, or I didn't get my how to rent booklet. There is remarkably little in the statutory instruments or in terms of case law guidance that deals with methods of service for these documents. And so what I'm going to try and go through briefly with you now are some of the background legal framework, some of the cases, some of the appellate cases that have been relied on in relation to various different proposed methods of service, and then touch on a recent county court decision which grapples with it head on, which is particularly noteworthy because permission has been given to the Court of Appeal to give a definitive answer on what we should be doing. So starting first with the legal framework and what the Assured Shorthold Tenancy Notices and Prescribed Requirements England Regulations 2015 is they say that your Section 21 notice is invalid and cannot be served unless you've provided the tenant with copies of various documents. We know that those documents are the Energy Performance Certificate, the Gas Safety Certificate, and the prescribed information in the form of the How to Rent checklist. My view is that unless there is either a provision in the tenancy agreement that allows you to give service of document by email, or you have specific written authority from the tenant that says, I am happy to receive documents by email, the safest thing to do is to provide hard copies of all of those documents. It's going to save you a ton of bother further down the line when you get to court, and it's going to save you the argument for at the expense of, unfortunately, a few trees and maybe a couple of postage stamps. But my view would be, unless there's specific authority from the tenant otherwise, don't serve it by email, provide a hard copy of the documents. The wording in the regulations is just that they must be given to a tenant, and so it's open to interpretation either way. But as I say, I think the safest course of action is to provide hard copy versions of the documents, then there can't be an argument. The second bit of statutory framework that's relevant for this talk is the Interpretation Act of 1978, and in particular Section 7 of that Act. I've set out the provision in full in the handout, and it's worth looking just briefly at the wording of it. So the wording of Section 7 is where an Act authorises or requires any document to be served by post, whether the expression serve or the expression give or send or any other expression is used, then unless the contrary intention appears, and pay specific note to those words because we're going to be coming back to that later on, the service is deemed to be effected by properly addressing, prepaying and posting a letter containing the document, and unless the contrary is proved to have been effected at the time at which the letter would be delivered in the ordinary course of post. That piece of legislation will become significant later on when we get into this debate about, do you need to serve them personally, or is it enough to put them in the post? The reason that is important is because in a number of decisions, there have been really two appellate authorities that are frequently cited that give you conflicting views of whether you need to personally serve or whether it's enough to stick the documents in the post. The first of these authorities is Wandsworth London Borough Council and Atwell. The brief background facts to Wandsworth are these. The council sought to terminate a tenancy agreement by way of service of a relying on the provisions of the Law of Property Act 1925. And what happened in that case was one of the tenants had left the country and gone to live in America. And so the council attempted to serve this notice in two different ways. The first way they did it was by leaving a copy of the notice at the property. The second thing they did was to send by post a copy of the notice to an address in the United States where one of the tenants had moved to. In this case, the court at first instance said notice had been validly given. This went to this went up a stage, and it was held that notice in that case had not been validly given. And what the authority in Wandsworth said was that if a landlord wanted to render valid and effective service of a notice to quit, and what this has been used as expanded to in more recent cases is service of the prescribed documents that you require before you can serve a Section 21 notice. Unless there is a provision in the tenancy agreement that allows for service of such documents by post, then what you have to do is go one step further than just showing you've either posted it at the address or you've left it at the address. What you've got to show is that the notice in this case, and more subsequently the prescribed documents, were actually brought to the attention of the tenant. So what Wandsworth had been cited for regularly in relation to these Section 21 claims is that it's not enough just to leave it at the property or post it to the property. You've got to show that the tenant has received it and has been aware that they received it, which, as you can imagine, potentially causes a number of significant difficulties for landlords, because what that effect means you'd have to do is effect personal service for all of it and provide a certificate of service in relation to the same. The flip side of that is the Court of Appeal decision in 2012 of Freetown Limited and Asset Hold Limited. Now, the facts in Freetown aren't particularly important. Freetown related to an appeal against a party wall award in a party wall dispute, and whether or not the appeal had been lodged within 14 days of service of the decision of the party wall award. But what is of particular significance in these Section 21 cases is the observation that Lord Justice Ricks made at paragraph 25 of the judgment, which I've set out in my handout, but it's important, so I make no apologies for reading it out to you now. What Lord Justice Ricks said was, it's submitted on behalf of the appellant that these provisions, that being the party wall provisions, suggest that Section 7 will at least generally apply to statutory provisions authorising or requiring the service of notices affecting land. I would accept that Section 7 provides a general statutory code regarding sendings by post, and that the statutory presumption is that it will apply unless a contrary intention appears. So what Freetown is authority for, and has been used by landlords on their side of the Section 21 service argument, is that because the regulations don't say you can't serve it by post, the general presumption is that the Interpretation Act and Section 7 of it will apply, and that you're more than able to serve these notices by post, and that's absolutely fine. And what that leaves us with, unfortunately, is a pretty knotty little conflict, with no case law one way or the other saying, can you serve these documents by post, or do you have to effect personal service and make sure the tenants are aware of them? That brings us to the recent County Court authority of Daubney and Carn, which was heard in December 2023 in the Central London County Court, and the judgment was published earlier this year. The facts in Daubney, as I've said in the handout, are probably ones that are familiar to a number of you who do Section 21 possession work. Daubney's the tenant and rented a property off the landlords who were the Carns. The Carns sought to bring possession proceedings against the tenant relying on Section 21 of the Housing Act. Predictably, he says with his cynical hat on, the tenant disputed validity of the Section 21 notice and said, I've never received copies of my EPC, my gas safety certificate, and the How to Rent booklet. I've never got them. The landlords, thankfully in this case for them, had been more diligent than a number of particularly in-person landlords that you see in the county court on a regular basis, or landlords who haven't availed themselves of your excellent services. And what they had done was they'd retained proof of postage. So they sent these documents via recorded delivery and were diligent enough to have kept the receipts. The deputy, it was Deputy Judge Davis, at first instance, found as a fact, and this is important for this judgment, that they accepted the landlord's evidence that these documents had been sent by post. So the evidence was that they brought along, as I understand it, to trial and exhibited copies of the receipts from the post office saying these had gone in the post. And it, as usual, the judge had said, well, were there any problems with the post in your area at the time? To which the tenant couldn't say that there were. So it was found as a fact that they had sent these documents. This led to the argument on appeal about whether or not it was valid to serve these documents by post or whether you had to serve them personally. And the reason that I'd cited Wandsworth to you earlier and then Freetown to you after that is because the tenant appellant cited Wandsworth and said, no, postal service is not good enough. You need to serve it on me personally. And the landlord respondent said, no, Freetown says we don't have to serve it personally. We can serve it because Section 7 of the Interpretation Act applies. And unless there's a contrary intention in the statute, we're allowed to serve it by post. But there was also an argument about whether or not, in fact, there was a clause in the tenancy agreement that allowed for the service of documents by post. In Daubney, it was found that there was such a clause in the tenancy agreement. And so even if the judge said, ultimately, even if I'm wrong about the Freetown versus Wandsworth conundrum, that doesn't matter because, in fact, there was a provision in your tenancy agreement which allowed for service of documents by post. But specifically on the point of whether or not Section 7 of the Interpretation Act applied, Her Honour Judge Boucher went into that in some detail. I've not included in the handout, but I do have a copy of the approved judgment in Daubney, and so if anybody wants a copy of it because they're struggling to sleep at night, feel free to drop me an email afterwards and I'll provide you with it. But what Her Honour Judge Boucher found was in favour of the landlord's interpretation. And when I said we would go back to it, what was significant in the judge's view was the use of the phrase in Section 7 of the Interpretation Act, unless the contrary intention appears. So going back, if you turn back to it if you like, but just refreshing you in case any of you have forgotten the thrilling details of Section 7 of the Interpretation Act. Where an act authorises or requires any document to be served by post, then unless the contrary intention appears, service is deemed to be effective by posting it. And what the judge in Daubney found was that that was of particular significance. And in essence, what was said was that if, like the tenant appellants argued, every piece of statute had to say, you are allowed to serve this by post, it would render the wording in the Interpretation Act of, unless the contrary intention appears, absolutely redundant. And what the judge also went on to say was that Lord Justice Ricks's comments at paragraph 25, which you already looked at, were significant and of general application to these sorts of cases. So again, saying that the statutory presumption is that Section 7 of the Interpretation Act will apply unless there is a contrary indication in the legislation. What the judge said in Daubney, as a more overall observation, is that that courts generally ought to take a broad application of Section 7 of the Interpretation Act, and it distinguished Wandsworth factually on the basis that Wandsworth specifically related to notices to quit under the 1925 Act, as opposed to applying more generally. And so the position at the moment, obviously in a non-binding county court decision, is that you are able to serve these documents by sticking them in the post rather than having to effect personal service on a tenant. This is one to keep a close eye on, though, because we know that permission has been given to appeal Her Honour Judge Boucher's decision to the Court of Appeal. I don't know at this stage what the listing status is of that appeal, but I would imagine that within the next 12 months, we're likely to get a definitive Court of Appeal ruling one way or the other. And with a risk of ending up with egg on my face and making a prediction, my view and my guess is that the decision that was made by Her Honour Judge Boucher will be upheld. I suspect that what the Court of Appeal will say is that it is good enough to send these documents by post, and it will be too onerous to require personal service. But you can all quote that back at me when I'm here next year and tell me what an idiot I was when I got that wrong. Just in the meantime, while we wait for guidance, I've set out in the handout, and will repeat up here, a number of what I would say are practical tips to avoid you getting into trouble one way or the other. And the first, if you are acting for or advising a landlord, the landlord has control of that tenancy agreement, and most of the time is the one who gets the say as to what goes in it and what doesn't. So make sure that your tenancy agreements are drafted to include a clause that permits service of the documents via post. If you've got a clause in there that's signed and says, we're able to serve notices on you via post, you're not going to run into these difficulties, I would say. Secondly, and again, seems simple, you'd be amazed, or maybe you wouldn't be amazed because you're all litigating these things, how often this doesn't happen. Ensure that your client's records are accurate, so that if you are sending a notice to somebody or visiting somebody's house to effect personal service, that you're going to the right address. Thirdly, keep the receipts. If you're sending out documents like this or a notice seeking possession, send it via recorded delivery and keep your proof of postage. And if you have a receipt that says you've sent something by recorded delivery, most, if not all, deputy district judges, circuit judges will say, yeah, I accept that probably got there. Lastly, and on a similar note, one of the best ways of showing that tenants have received documents is by showing that they've received other stuff that's been sent in the same manner. So if you're sending them notices, communications, rent statements by the post, and you've got evidence that they've been responded to, chances are they also got the other stuff that you sent them by post and they're now saying that they didn't.